Welcome back. In this lecture, we're going to look at the growth and development of international law. And when we discuss international law in this context, we're going to be talking about international public law. So we look at the question of what is international public law? How do we know what is international public law? Well, there is this traditional definition, which we mentioned in the previous lecture, which is to say that international law, public law, is the law that governs relationships between states, interactions between the states. But of course, before we can answer fully the question of what is international public law, we have to first of all look at what is the law. When we talk about the law, what is it that we're discussing? We know that the law is a system of rules. And these rules are meant to govern the interactions between members of a community. Meaning the system of rules is going to govern how the members of the community interact with one another. But it also refers to the rules that govern how an individual in the community interacts with the community as a whole, within society as a whole. So there are these two aspects of the law, which is to say the law that governs the relations between individuals and the system of rules that governs relations between the individual and society as a whole. And you can see that in our own division here in the United States between criminal law and civil law. So if you are walking across the street and you are struck by a drunk driver, there's actually two types of law that are going to govern that interaction between you. And the first would be criminal law, which is to say a harm has been suffered by the state when that accident occurred. Someone has violated the rule against drinking and driving, and they have violated the rule that says they should not hurt somebody while driving a car. So those rules are meant to protect society as a whole. We want to protect society as a whole. If you ever watched a TV drama involving a criminal court case, we know that the plaintiff, the first person complaining in a criminal court case, is always the state versus John Doe, or the people versus Mary Roe. So criminal law is that body of rules that regulates interactions between the individual and society as a whole. Now, civil law relates to the interactions between two individuals. So the person that hit you while you were crossing the street is not only liable to society as a whole, which they can pay back through going to jail, for instance, but also they are liable to you individually for the harm that they have caused. So you have a right to sue that individual for the harm that they've caused to you. So there is a separate body of rules that applies to that interaction. So when we are looking at international law and the interaction between the states, international law is the law that regulates interactions between individual states and the body of rules that regulates interactions between the states and the international community. So there are these two aspects of the law. Now, since the end of World War II, the notion of international law has expanded greatly. As I mentioned in the introduction to this course, the question of is international law real has played a part in discussion of international law. And in recent years, it's become even more a larger part of that discussion. But in any event, if we are going to take the position that international law is real, we know that since the end of World War II, there's been a great expansion of the idea of international law. And so what we'll be doing in this lecture is to look at the growth and development of international public law. All right, we'll stop there. We can break that up. There'll probably be 4 different ones in this course. All right. We'll take up again part 2. So in this part of the lecture, we're going to look at what are the different philosophical bases for international law. See, the law, this system of rules, has to rely on something. And to answer that question of what is the support for the law, we turn to philosophy. And international law, just as domestic law, actually has 2 foundational bases. There are 2 pillars that support the idea of international law. And the first of these pillars is what we call the natural law. International law can be based on natural law principles. The second is international law can be based on positive law principles. And in this lecture, we're going to be looking at the differences and the similarities between those 2 foundational bases. Both of those foundations are valid support for the establishment of an international law. We're going to be looking at the differences, though, and how they are interpreted. And we'll start with that question of what is the natural law? And you may be familiar with this concept from your first legal studies course. Natural law is the belief that there are laws in nature that cover the interactions between individuals and the interactions between individuals and society as a whole. That there are already pre-existing laws that may have come from God, or we simply may be able to determine what these laws are by looking at how it is that people live their lives. So when we first developed the idea of international law, many said that the law of nations was essentially a subset of natural law. In the same way that there are natural law principles that govern how we interact with our neighbor, how we interact with the state as a whole, we could deduce these same principles in regards to international law. Now, natural law is often seen as being a connection to a deity or to God, that the authority of law is connected to God, and that there is a law that is the superior law regardless of what man's law would say, that there is a higher law. And this is a position obviously from Martin Luther King Jr., that we have to break the law because we are following a higher law. We are following God's law. Or, as I said, it doesn't have to be connected to a deity, but generally is. Now, natural law has some defining principles, meaning these principles underlie what we would call natural law. And the first is restitution. Restitution must be made for the harm done by one party to another. So when I discuss torts law, for instance, tort law is when you injure another party either intentionally or through negligence. Well, the idea of restitution says you owe that party. You need to put that party back in the position they would have been in had the harmful act never occurred. So restitution. When we look at what it is that gives you the right to sue the individual who ran into you, it's that idea that because they have harmed you, they owe you restitution. They must make good for the harm that they've caused. In fact, in the Louisiana Civil Code, the foundational principle of all of tort law in Louisiana Civil Code comes from this idea that if you do harm to another, you're obliged to fix that harm. So restitution is a defining principle of natural law. Natural law also holds that a promise given must be kept. And there's the Latin phrase, pacta sunt servanda. But what it essentially says is that if you give a promise, you should keep the promise. So again, here, of course, that relates to contract law. That if you have given a promise, you are obliged to keep your promise. And if you don't keep your promise, then we go back to Rule 1 that says you owe restitution for the harm you did by not keeping your promise. So promises given must be kept. This is another defining principle of natural law. And this applies not just internationally, but domestically as well. Now, this third element is definitely international in nature, and it's the idea of freedom of the seas. Now, freedom of the seas is a concept you probably don't think about as even being controversial in any aspect. That a ship in international waters, which is to say in waters that are not controlled by any country, should have the right to freely go and come as it pleases. That this is what facilitates commerce. We have a rule that says if ships are from states that are not at war, then there is a law that says you can't interfere with that ship. The United States has the largest, most powerful navy in the world, but we don't use it to go seize cargo ships and take the cargo and keep it for ourselves. Why? Because of this concept of freedom of the seas, this natural law concept, that this is the way the world works. The world could not work without freedom of the seas. So that's natural law. Now, in opposition to that, we have the idea of positive law. So what is positive law? Well, under positivist thought, the authority of the law derives from the sovereign, meaning the law only exists because the sovereign says it's the law. In a positive law context, the law requires a sovereign who is going to issue commands and also provide a means of backing up those commands with negative sanctions. So positive law says essentially that the highest law is man's law, meaning the law that the sovereign has provided. Now, the sovereign could be a king, but the sovereign could also be the elected representatives of the people. And so when we look at the idea of positive law, we know that the highest law is the law enacted by the sovereign, by, in this case, the people. Now, under positivist thought, there is not necessarily a connection between law and morality. From a natural law perspective, you would argue that the right law should be the moral act. Whatever is the most moral act is the most ethical act. That should be the law. But when we look at it from a positivist perspective, there is not a connection, necessarily a connection between the law and morality. Now, we would hope that the two are somewhat the same, but there doesn't have to be that connection. That the law, whatever it is, the law may differ from morality. And the reason why is that morality is oftentimes a very subjective notion that a person may have as to what is the moral choice. So from a positive perspective, we don't have to rely on whose morality is going to govern, because the right choice is going to be reflected in the law that's issued by the sovereign. As an example, there is a federal law that prohibits assisting people who have entered the country illegally and are attempting to immigrate into the country without following a legal process. So there's a law that says that. Now, that law presumably reaches even those people who leave water in the desert for people that have crossed the border so that they don't die in the desert. Now, are those people, if we look at it from a natural law perspective, those people are following a higher law, that even though the government of the United States says this is against the law, the higher law says, well, we should give water to thirsty people. We should prevent people from dying of thirst. The positivist perspective would say, look, there's a law, and if we follow that law, it's better for everyone. And therefore, we don't rely on these subjective notions of what's the moral choice or not.